Amendment number 4, Lord Eatwell.
This amendment addresses a concern which was discussed at the time when Mr. Herzl was giving evidence. I asked Mr. Herzl whether, given that in many instances of risk-taking these days, statistical analysis is done by insurance companies and credit card firms, which would not be obvious to the consumer as relevant to the risks that they take. And in those circumstances, was there a clear obligation, I asked Mr. Herzl, on the insurer to clarify the relevance of the question? And the answer was no, there was not. And therefore, I think that given the responsibility which the consumer has to answer the questions asked, it should be clear to the consumer that questions are relevant, even though they may be derived from some form of statistical model which identifies relevant factors which might not immediately, to the ordinary reasonable consumer, be deemed to be relevant. So it is important, I think, that the questions should be such as to be deemed relevant to the contract to a reasonable consumer. And if they involve some more arcane form of analysis, then that should be made clear so that the reasonable consumer is suitably protected and suitably informed and can discharge his or her responsibility to answer questions in an appropriate way. Now, I should apologize to the committee in that I failed in putting forward this amendment to realize the inconsistency that would be created by the point that is the clause that is available in 5.5 subclause 5b, which is the part which supports Mr. Herzl's position that the consumer should deem a question to be relevant simply because it's been asked. And I do not think that is satisfactory. I think that puts an excessive burden on the consumer. And what I should have done was introduce the consequential amendment, which was to delete 5.5b. And I apologize to the committee for not doing that, but we do have report stage at which such a tidying up could be done. So I would like to suggest that my amendment provides a framework within which the reasonable consumer is suitably informed with respect to the responsibility that he or she has in answering questions. I therefore beg to move.
Amendment proposed, page 2, line 26, at end insert the words printed.
My difficulty with this amendment is that, in fact, all Clause 3.2 is doing is giving examples of things which the Court's got to take into account, as I understand it, in deciding whether reasonable care has been exercised or not. One could, of course, add a lot of other examples of things which might be taken into account. But surely we can rely on the Court, can't we, to make a sensible or reach a sensible conclusion in the light of the points which the noble Lord has made. And it doesn't have to be spelt out in the statute. Then I'm particularly worried, or would be much more worried, if it is, as is now accepted, that we would need an amendment to Clause 5.5, and that, I think, raises much more serious questions. That if we're going to delete that, I would be very concerned.
My slight concern about this is that if, as my noble friend the Minister has argued, 3.2a, the type of insurance contract in question and its target market, deals with proportionality, it probably also deals with relevance, because it would seem to me that is in the same area. And therefore, if we accept the Minister's argument in respect of that, then it seems to me that actually it applies here as well.
My Lords, I find this almost the most difficult amendment of the afternoon, in the sense of trying to disentangle what the intention of the amendment is and the possible consequences of it, because as the noble Lord, the noble and learned Lord Lloyd of Berwick says, actually what we're talking about is a list of factors that may need to be taken into account by the court to determine whether or not, in making a determination. But on the other hand, I think we risk confusing that aspect with the question of what the consumer is supposed to know or to take into account at the point of entering into the contract or answering the questions, which is a rather different matter. And the main thrust of the bill, of course, is that consumers should not be expected to know what information is relevant to an insurer. We're trying to protect a consumer, make it as simple as possible for the consumer, and not have to have them step into the shoes of an insurer and make all sorts of complicated judgments and assessments that would flow from that. And that is the position that the consumer shouldn't be expected to know what information is relevant to the insurer. That is the position under the Marine Insurance Act, which this bill is seeking to update. And therefore, my starting point would be that it follows that the use of likely views of a reasonable consumer, whoever he or she may be, as a benchmark of relevancy is not an appropriate test. It is important that when seeking remedy against a consumer, insurers should be required to defend their rationale for asking certain questions of the consumer. However, I don't think that they should be bound to consider the likely views of a reasonable consumer when deciding which questions to ask. Ultimately, the insurer will be in the best position to know what information is needed to be provided in connection with the particular insurance policy. And as I've said, in the event that an insurer attempts to take remedy against a consumer, the insurer will need to demonstrate the relevancy of the questions asked, and at that point it would be for a court or another relevant adjudicator to make a judgment around the validity of this demonstration. And I don't think it would be appropriate to limit the decision-making capability of the court or adjudicator by requiring that in making the judgment they consider in particular whether a reasonable consumer would have considered the question relevant. Rather, it is for the court or the adjudicator to decide whether they agree with the insurer's demonstration of relevancy that should encompass a whole range of factors. There could be many instances where if an insurer or a court or an adjudicator were to consider whether a reasonable consumer would consider the question relevant, they might conclude that such a consumer would not. However, this doesn't necessarily mean that the question was not relevant. More likely it's because even a reasonable consumer would not be in a position to know what information is relevant to an insurer. And that is very much in line, I would suggest to the committee, with the overarching principle of the bill. And of course I should say the point about clause 5.5, which again the noble and learned Lord Lloyd of Berwick immediately picked up on, that any change to clause 5.5 would be a very major change to the balance of the bill, and it would change the definition of deliberate and reckless actions. So as well as suggesting that this Amendment 4 in itself is inappropriate, the fact that the noble Lord Eatwell is good enough at this point to point out the linkage to clause 5.5, I suggest would go to the very heart of the construct of this bill, and I would ask the noble lord, therefore, to withdraw his amendment.
My Lords, I'm grateful for the comments which have been made on the amendment. I would just take up 2 points. First of all, the noble Lord Lloyd of Berwick said, could we not rely on the courts to reach a reasonable conclusion about relevance? Well, no, we can't, because 5.5 prevents them from doing so. 5.5 says that unless the contrary is shown, it is presumed that the consumer knew that a matter about which the insurer asked a question was relevant. And that is the theme which was presented to us by Mr. Herzl in his evidence, which I find objectionable. I'd like to give, because I've done some work in this area, an example to the committee. If you're asking questions, for example, with respect to somebody's income, and you say, how much do you earn every year? And the person says, £19,532. Statistically, that will be believed. If they say £20,000, it will not be believed, in the sense that anybody who presents their income as a round number, the weighting of that answer is much lower than if they present a number which is not rounded, but which is precise. And yet there's no way that a reasonable consumer would know that unless they'd actually worked in the risk analysis business. So I think there is a real issue here with respect to 5.5, which I was attempting to deal with, but I admit attempted to deal with very, very inexpertly in this case, and it would be quite unreasonable for me to do anything other than, at this stage, withdraw my amendment. But I hope to pursue this matter at a later stage. And, my Lords, I beg leave to withdraw the amendment.
Your Lordship's pleasure is amendment withdrawn. Amendment is by leave withdrawn.